I think you probably know that among the Armenian public, the trust in these human rights institutions and mechanisms are at a low, probably because during the entirety of the blockade and with public TV as well, it was promoted that perhaps we're waiting for this court or this international mechanism or that. As we sat there doing nothing, and even when we got the ICJ decision that this blockade was illegal, right, and Lachin needs to be opened up, it didn't really result in any action. So my question is there a component missing, perhaps because these legal uh, frameworks should work in tandem with the political and military will of our country? And if that were the case, right, if we militarily opened Lachin, as we had done in the 90s when we were dealing with a similar case of a blockade. I know that blockade is a part of part of aggression. It's considered a war action. So would these international decisions work in defense of Armenia, opening the Lachin corridor and putting an end to the blockade? Could you back us up on this?
So first, Armenian policy is not consistent and uniform. And alarmingly, it is contradictory, which is not in the interest of Armenia. So the actions of legal team are not in line with political team, and we see actions and announcements from political team which intentionally endanger the legal proceedings. So they even sabotage the legal proceedings. So my conclusion is that we don't have any uniform policy within government, and we have these competing issues within government, and some mechanisms should be introduced to secure firstly this uniformity of Armenian policy and alignment. So if the government is of approach that we don't have any legal claim, so the good way would be to withdraw its cases, apologize publicly to Azerbaijan, and make such statements supporting this Azerbaijani narrative. But when this is not done and Armenian government is in pursuit of legal proceedings, it is unacceptable to tolerate contradictory political announcement, not in a spirit of legal standpoint, position openly delivered during these court hearings. So the next part of the question concerns execution, right, of ICJ ruling about Lachin corridor. So the military way is possible. So Armenia had a legal ground to militarily, by resorting to military force, open Lachin corridor, and considering the existence of ICJ ruling, there was no possibility of blaming Armenia for aggression. However, I don't think that after the 2020 war, Armenia and overall the army was in a spirit and at an organizational level to start any military action against Azerbaijan to execute the court decision. So the only possible way was with the help of international community. So political work to pressure on Azerbaijan to implement the judgment. However, again, I don't see that very effective diplomatic and political measures were taken to achieve this aim. Meanwhile, Azerbaijan, like following its plan of ethnic cleansing, started military operation, and now we have what we have.
I see. I know that there was a report on Artsakh ethnic cleansing, but then sometimes we see U.S. officials maybe fighting against or refusing to call this ethnic cleansing. So, what is the value of having the status of ethnic cleansing? And would you tell us a little bit more about the report and its conclusions?
So in this report, we argue that ethnic cleansing happened in Artsakh, and we identify the factors which are important in qualifications a case as ethnic cleansing or other situation. And by offering this internationally recognized criteria, we concluded that Artsakh is a typical case of ethnic cleansing. However, ethnic cleansing is a term which is used from political perspective. If we are discussing the legal part, in legal terminology, we don't have ethnic cleansing. We do have like forced deportation, persecution, we have genocide, and then those are actions, and we have international criminal law which would qualify all or some of those actions as war crime or crimes against humanity. So when we are discussing the situation in the context of international politics, then we use this term of ethnic cleansing. However, we think that from legal perspective, the actions at stake are persecution, forced deportation, which are crimes against humanity. But since 2021, Azerbaijan also committed other war crimes on the sovereign territory of Armenia or in Artsakh, which was under Armenians' extraterritorial jurisdiction. And we think that those war crimes also should be punished. And the mechanism to bring the issue for individual responsibility is International Criminal Court. Armenia has ratified the Rome Statute. We are waiting to see whether this referral from Armenian government to a court would ever happen. But irrespective of this step, again, non-governmental organizations, they work on Article 15 submissions to provide information and proof of committed crimes to the prosecutor, which would then have a discretion to open criminal investigation on Armenia's specific situation. And our organization will use this report and our data, which we are now collecting through fact-finding mission, to make submission to ICC covering cleansing, but legally formulating it as crimes against humanity and war crimes.
I see. Now coming to our internal political prisoners here in Armenia, do you see any similarities with how Azerbaijan's regime and the regime in Armenia work in regards to like suppressing opposition, free speech, etc.? And also, what process do you see happening in our legal system in this past years? What is the state of our judiciary? Is it independent of the governing body? Do we have accountability, transparency?
I would say we have a decline in rule of law in Armenia. So after revolution, the expectations were that Armenia is a fully democratic country with high rates of rule of law index, freedoms, and so on. And these expectations were reflected in assessments of and also reports of international organizations. And over a few years, we have seen this support from international human rights organizations and governments to Armenian authorities. However, very gross forms of violations occurred. And now those organizations are facing this challenging situation, and now we see this trend of raising concerns about human rights issues, judiciary related aspects in Armenia as well. With all this support, we have so apparent cases that international community cannot anymore close their eyes because of political support to Armenian authorities. This Artsakh issue is very useful in the hands of Armenian government because for internationals it's critical to have this issue closed in the region to ensure security, peace, and this conditional peace also would mean a change of Russian influence over this region, and international organizations demonstrate more interest in resolution of Artsakh-related issues rather than internal democratization processes of Armenia. So they are ready to support Armenian government and not make obvious the violations that are happening by these authorities to the extent they work closely in resolution of Artsakh-related concerns. So we see a trade between Armenian government and Western societies. But again, they can tolerate it to certain extent of a certain limited time period, but they cannot tolerate those violations indefinitely. And in my assessment, we are now in a critical point where international starts covering internal human rights violations as well.
I see. Could you tell us a little bit more about your partnership with the Armenian Legal Center, how it emerged, and what are some results that we have today?
So basically, Armenian Legal Center is the organization which noticed our work because we have been doing this work from 2000 and were very active at the beginning of 2020. They noticed our work. They realized the importance of such work to be done on behalf of the victims, independent from state's position. They also were mindful of the required resources to successfully implement such efforts, and they established cooperation. So through talks, we were able to prioritize the actions needed for Armenian at this specific period. We compiled a strategy assessing also all risks, internal risks as well, political risks as well, and with their support, we are currently implementing this action. In terms of achievements, so our activities resulted in publication of many reports which identify human rights violations, crimes during 2020 and afterwards. We are the only organization doing victim representation. So we diversified these international legal proceedings by acting based on individual application tool, and we create some security in case Armenia, under pressure of Azerbaijan, will withdraw its interstate case. So if this happens, this means the only legal battle should be continued by us, and there are limitation periods. So basically, if you miss the relevant periods for bringing action internationally, this 4 months period, for some instances 6 months period, then later you cannot raise this issue as it will be considered beyond permissible time limit, and those claims will be declared inadmissible. And with our legal action, we will fill the gaps, and at the end we'll have rulings based on Armenian cases. So this litigation is a key, and it will become very strategic and crucial in a light of withdrawal of interstate cases. We have prepared sanction packages. So this accountability part is key for our activities, and those submissions were made not only with US government but also European Union. We are working on Canada, Australia, UK, so we'll expand this geographical coverage of sanctions as well. We are collecting witness testimonies to document the history, and those testimonies are used for international legal proceedings. We are working also on Article 15 submission to the prosecutor of International Criminal Court, and we have more planned activities.
I know that Pashinyan recognizing Nagorno-Karabakh as a part of Azerbaijan, there's a possibility of this retroactively making us an occupying force, as far as I know. And Azerbaijan then is legally justified to ask for reparations that may come in money form or in land form. Essentially, how serious are those concerns?
Those declarations have a value. So the announcements by ordinary people do not contribute to creation of international law. However, the position of heads of state, heads of governments, Minister of Foreign Affairs, and other key officials has a meaning and can create consequences, even legal consequences for the state. Those announcements are attributable to a state, and they can again contribute to creation of international law. And from this perspective, they are very dangerous announcements. They are against Armenia and Artsakh's interests, and they can give rise to legitimate claims against Armenia as a state so-called occupying part of Azerbaijan in the past 30 years. And this can lead to compensation-related issues as well. And why not? Those arguments, those announcements can weaken the position of government, Armenian government, in interstate cases before ICJ or European Court of Human Rights. So they are harmful announcements, and they are especially harmful for Armenia's interests. And I don't know whether those announcements are made intentionally, or the lack of legal knowledge gives rise to similar announcements, and they don't really realize the consequences of their own announcements.
We see that Azerbaijan interferes quite a lot in Armenia's internal life. They seem very aligned with each other nowadays, the Armenian and Azeri government.
Yes, this discussion is valid also from the perspective of demanding changes in the Armenian constitution. So constitution amendments, adoption of new constitution, changing legislation, lawmaking is within the exclusive jurisdiction of sovereign state, and international actors, foreign states, cannot impose such rules on governments to change their legislation. The only possibility is within a system where they assess legislation from the perspective of international standards. But again, here they can only recommend the country to improve its legislation. However, this constitution making remains within the power of population of a country. Constitutions are made and modified through referendum, and no state can compel, enforce people how to exercise their popular sovereignty and what provision prescribed in their own constitution. And those the constitutions are very important in terms of identity building of a nation. And with this demand, Azerbaijan wants to intervene and design how we as Armenians should be in future. So they are creating risks for our national identity, for our common goals as Armenians as well.
Yes, that's terrible. I wish someone would do something about this. But in terms of negotiations, we have two states. Two last questions. We have two states, one of which is very ready to use force, and another that consistently says and also actually refuses to use force. And when they're negotiating some sort of agreement, the Armenian side as well refuses any third parties. How is it possible for such an imbalance of power to come to an agreement without a guaranteeing, reinforcing third party? Is it?
I think this again shows non-genuine nature of those negotiations. and questions the real aims behind those negotiations. So we have seen negotiations with the involvement of third parties and then failure to implement the commitments, like it happened in 2020 during November 9 declaration. Negotiations happened. We have a third country as a guarantor, but we faced non-implementation of the undertakings, even on humanitarian matters. As to this date, Azerbaijan is refusing even to repatriate 5 prisoners whose captivity happened in 2020. So they classically come within this November 9 trilateral statement. And then we see how Armenia proudly talks about bilateral relations with Azerbaijan and vitality of the negotiations. We see discussions over this peace treaty consensus about 80% of provisions. But at the same time, those signed documents remain on paper because undertakings towards Armenia are still non-implemented. And no securities are being created, also in the form of maintaining the ongoing legal cases. So this situation alerts that we have non-genuine negotiations for the interest of Armenia, and behind closed doors arrangements are made which are not in the best interests of Armenia.
And finally, what part of your work or what one case you're most proud of through your life and career?
It would be very difficult for me to identify a specific case because all the cases are relevant. They are of strategic nature. They address systemic issues. So I can reformulate it in a way that I'm proud of my work that I'm doing in the area of human rights protection. So I have other parts of my work. This includes academic work, research. As an attorney, I do representation before domestic courts. I deal with business-related legal issues. I have wide spectrum of activities, but I'm proud of the part of a work which I'm doing for Armenian. And with the help of this work, trying to contribute to better protection of Armenian within this wild order in international arena. So the work for international protection of all Armenians is the most crucial part for me.
Thank you so much, Siranush, for your commitment to justice and for coming on today. And we'll see you next time.
Thank you.